Well, Dan, we had a real estate client who was a successor trustee. They sold the property, and everybody seems to be happy now that the most valuable asset was sold. But once it's sold, what happens? And what happens to the monies? Where does it go? When they should wrap things up? What happens with taxes? Can you kind of shed a little light on that?
So I'm guessing the most valuable asset was a property, maybe a
Yes.
primary residence?
Yes.
Okay. Well, this is a common question. How do you wrap up a trust? When do you make the distributions? In what order? At what age? And, when it's a living trust, it can live on for quite a while. There's actually a limit in the state of California on how long a trust can live. They're not actually immortal. In fact, it's called the rule against perpetuities. And that says that a trust has to actually be distributed within the youngest living beneficiary alive at the time of the death of the creator of the trust, and then plus 21 years. So that's usually, like, if there's a grandchild that's alive, then it's going to be their whole lifetime plus 21 years. And that could be a grandchild or a great-grandchild. So it could be 2 or 3 generations at the max. But the basic answer is, when do I make the distribution from the trust, whether it's the net closing proceeds from a sale of property or stocks or real estate? The answer is, first, look at the trust. So we have to look at the trust, see what the trust says. The trust might say, distribute everything to my children immediately or as soon as practicable, because they're all adults. And if it says immediately or as soon as possible or as soon as practicable, then the distribution better happen pretty quickly. And I don't mean, within 24 hours. I don't even mean necessarily within 30 days, but generally within, a month or 2 or 3, maybe, right? And if the family is all in agreement and the trustees are still in the process of selling a property and they need a couple of extra weeks or months, that's okay too. But certainly, if it says as soon as practicable, the distribution shouldn't be taking place in 5 years. It should be, they should try to wrap it up within a year, right?
Yes.
But sometimes the trust will say, it doesn't say, give my kids their money as soon as possible. What it says is, give them the money when they're 40, or half at 30 and half at 40, or when they're 50. And so, again, if you look at the trust instrument, you're going to see you're going to see the answer to the question, when to distribute it. It's going to tell you as soon as possible, or it's going to give you an age or something like that. And then in some cases, this is not so common, it might be a generation skipping trust. We call those dynasty trusts, which means that it's not going to be distributed at all during that person's lifetime. So in your case, Chris, the example you brought up, the property sold, that cash might sit in there for the children's entire lifetimes, providing them income and support. And then when they die, it'll go to their kids and it'll be distributed to their children when they're 21 or 25 or 40. So if it's not in the trust, then you look at the statute, which is governed by the rule against perpetuities. Otherwise, look at the trust and it's going to tell you. We had a case not too long ago where the person had died 7 years ago. One of the sons, there were 5 kids, and one of the sons inherited a property right on the ocean front.
Nice.
And he didn't inherit it. He was the trustee. But one of the properties was on the ocean, on the beach. And, of course, he's the trustee. He moved right into that property. Now, he's supposed to share it, I think, like 5 equal shares altogether, right? But he was in no hurry. He was sitting fat. He was happy. And there were a dozen other properties. It was a very large estate. He didn't distribute anything because he was fine. He was quite comfortable. So the siblings hired us to file a petition against him to compel him to make the distribution. Because the trust said, give us our money as soon as possible to all my adult children. Well, they were in their 50s. So they were certainly adults. And the court basically ordered him, look, you've been sitting on this trust for 7 years. That's too long. And the court ordered him to make an accounting to reimburse the trust for some expenses. and to distribute everything. So that's an example of somebody that definitely sat on the money and the property way too long, and the court's not going to allow that. But if the other kids hadn't come to us and we hadn't filed a petition, he might still be sitting on the beach, monopolizing all the houses, getting the income from all the houses, and because it's a living trust, it's not before the court unless somebody brings an action in front of the court in order to compel the trustee's good behavior. So that was a good question, and that question that you asked, when do you have to distribute the money from the trust? That question has to be asked on each and every trust after somebody dies, because right away the trustee should find out, when do I have to make this distribution? And guess who wants to know? The beneficiaries.
They're waiting.
Everybody wants to know, where's my money?
That's right.
Where is my money? When am I going to get it? And you look at the trust, and the trust is going to generally give you the answer.
So, Dan, there's instances where we've seen, properties still in the name of the living trust, for example, and that, I don't know if it has to do with the generation skipping trust or anything like that, but a lot of people worry sometimes that the taxes will reset if it's not a primary residence of the kid. So we've heard of, or at least what I've seen or what I've heard from this person was talking to me, we're like, well, yeah, the property's on title. Everybody's gotten paid out technically, but we're keeping the name of the living trust on that property, so the property tax is reset. That might be a different topic, but just wondering if you had a couple quick comments around that, because that has sometimes maybe to closing the trust out or define the language, and what if the beneficiaries are fine with that? I mean, I don't know. It's just one of those weird things that I run across.
I've seen it a lot too, Chris. The operational word here to describe that situation is denial. The family's in denial. They honestly think that, unfortunately, that if we just pretend that, Grandpa didn't die, he's still alive, he still owns the property, it's going to keep the property taxes low.
Right.
So let's just leave, Grandpa, who's gone, rest in peace, let's leave him on title. Or because it's not in the trust, it's in Grandpa Jones, trustee of the Grandpa Jones trust. That's actually what it says, right, in your example. It's still in Grandpa's trust under his name as the trustee. And nobody wants the property taxes to go up, so they don't file a death certificate with the county. They don't do that affidavit of death, and they don't clear title. So as long as the county thinks that Grandpa Jones is still alive, you're right, the property taxes stay low. And they're going to get away with low taxes for a long, long time. And sometimes, and we've both seen this, sometimes they'll leave it in the trust for years.
Yeah.
Now, the problem is that there will be a day of reckoning. And the day of reckoning is when money has to move. So whenever a mortgage gets taken out on the property, the bank's not going to lend to Grandpa. Grandpa can't sign anything. He's gone. So they're going to have to clear title. And when title gets cleared, the county tax assessor is going to reassess it all the way back to the date when Grandpa died.
Yeah.
Now, if he died before, I think it was February 16th, 2021, which is when Proposition 19 went into effect, then there might not be such a big reassessment. But if he died after Prop 19 went into effect, then it's going to get reassessed retroactively with interest and penalties.
Wow.
So maybe it's not a loan. Maybe they just sell it. Oh, let's just sell it now. But it's been in the trust for 8 years. Well, we might be able to get a Proposition 58 parent to child exclusion because the date of death was before February 16, 2021, before Proposition 19 went into effect. But if it was after that, escrow is going to see, you've had dead Grandpa on the property for 3 years, and they're going to, the county's going to find out about it, and either the taxes will have to be paid retroactively through escrow at the time of closing, or I've even seen this, they actually close and they prorate the taxes as they are between buyer and seller. Escrow closes, and then the old owner that's already sold the trust or the trustee gets a supplemental tax bill,
Oh, yeah.
like 6 months after escrow closes, and it includes the interest and penalties that escrow wasn't able to calculate because the county hadn't had time to calculate them. So if people think that they can just ignore the property taxes by leaving it in the trust forever, again, that's just denial, and it's going to come back to haunt them because they'll have interest and penalties to pay. But eventually, I mean, the best thing to do is just clear title, file the affidavit of death, get Grandpa's name off the title.
Yeah.
And now the trustee owns the property, and they can either sell it or distribute it to the beneficiaries, or keep it in the trust if that's the timeline that the trust dictates. But deal with the taxes instead of incurring interest and penalties, and keep the title clear. We don't like, for lack of a better word, this might be a bit blunt, but we don't want dead people owning property because it means the county's got something to do, and that's usually reassessing taxes.
Yeah. Well, Dan, I know we talked about some generational skipping trust in some of our other podcasts, so you can check that out on our channel on YouTube, TikTok, and visit moderntrust.com.
Yeah.